should start an investigation into the Bidens, because what happened in China is just about as bad as what happened with Ukraine.
The American people deserve to know what happened. The American people deserve to know when they go to bed tonight that there's a president that has their interests in mind, that will put the national security of the country above his own political self-interest. The American people deserve answers, and yes, it is still a good time to call Ambassador Bolton to testify.
Thank you, Mr. Manager. The Senator from Ohio.
Mr. Chief Justice, I send a question to the desk on behalf of myself, Senators Toomey, Cornyn, Crapo, Ernst, and Moran.
Thank you. Surprised to hear the House managers repeatedly invoke constitutional law professor Jonathan Turley to support their position, including playing a part of a video of him. Isn't it true that Professor Turley opposed this impeachment in the House and has also said that abuse of power is exceedingly difficult to prove alone without any accompanying criminal allegation? Abuse of power has never been the sole basis for a presidential impeachment and was not proven in this case.
Mr. Chief Justice, Senators, thank you for that question. And that is exactly correct. Professor Turley was very critical of the entire process in the House and of the charges that the House Democrats were considering here, both the abuse of power charge and the obstruction charge. And he explained that this was a rushed process that had not adequately pursued an investigation, that, as the senators point out in the question, abuse of power is an exceedingly difficult theory to use to impeach a president, and it has never been used without alleging violations of the law. And I think that in the discussions we've had over the past week and a half, we've pointed that out multiple times. Every presidential impeachment in our history, including even the Nixon impeachment proceedings, which didn't actually lead to an impeachment, have used charges that include specific violations of the law and the criminal law. Andrew Johnson was charged mostly in counts that involved violation of the Tenure of Office Act, which the Congress had specifically made punishable by fine and imprisonment, and even wrote into the statute that violation would constitute either a high crime or a high misdemeanor, but one of those terms to make it clear that it was going to be used to trigger an impeachment. In the proceedings, in the Nixon impeachment inquiry, each of the articles of impeachment there, except for the obstruction of Congress charge, was sort of treated separately on the obstruction theory, included specific violations of law. There were specific violations alleged in the second article of impeachment, which is often sort of referred to loosely as the abuse of power article. It wasn't actually titled abuse of power. It didn't charge abuse of power. The specifications there were violations of law, violating the constitutional rights of citizens, violating the laws governing executive branch agencies, unlawful electronic surveillance using the CIA and others, specific violations of law. And clearly in the Clinton impeachment, President Clinton was impeached for perjury and obstruction of justice. Those are crimes. And while Professor Turley does not take the view that a crime is necessarily required, he pointed out here that there was not nearly a sufficient basis and not nearly a sufficient record compiled in the House of Representatives to justify an abuse of power charge. He also was very critical of the obstruction of Congress theory, and he pointed out that it would be an abuse of power by Congress under these circumstances, where Congress has simply demanded information, gotten a refusal from the executive branch based on constitutionally based prerogatives of the executive, a refusal to provide that information, than to simply go straight to impeachment without going through the accommodations process, without considering contempt, without going to the courts. That was Professor Turley's view, how incrementally the House of Representatives would have to proceed if they were going to try to reach, ultimately, some theory of obstruction of Congress. So to cite Professor Turley, it is true that in his academic writing and in his testimony, he did not adopt the view that you must have a crime and only a crime as the charge for an article of impeachment. He still thought that neither of the articles of impeachment here could be justified or were sufficient or could be used to impeach the president, both the abuse of power article and the obstruction article. So taking snippets out of what he said really does an injustice to the totality of his testimony, because the totality of his testimony was entirely against what the House ended up doing here. Thank you.
Thank you, counsel. The senator from Ohio.
Mr. Chief Justice, on behalf of Senator Wyden and myself, I send a question to the desk for the House managers.
Thank you. Senator Brown and Wyden ask the following question for the House managers. During yesterday's proceedings, the President's counsel failed to give an adequate response to a question related to whether acceptance of information provided by a foreign country to a political campaign or candidate would constitute a violation of the law, and whether offers of such information should be reported to the FBI. FBI Director Christopher Wray, who was appointed by President Trump, has said, quote, "If any public official or member of any campaign is contacted by any nation state or anybody acting on behalf of a nation state about influencing or interfering with our election, then that is something that the FBI would want to know about," end quote. "And we'd like to make sure people tell us information promptly so that we can take the appropriate steps to protect the American people," end quote. If President Trump remains in office, what signal does that send to other countries intent on interfering with our elections in the future, and what might we expect from those countries and the President?
Mr. Chief Justice, distinguished members of the Senate, thank you for that question. To take the last part first, it would send a terrible message to autocrats and dictators and enemies of democracy and the free world for the President and his team to essentially put out there for all to consume that it's acceptable in the United States to solicit foreign interference in our free and fair elections or accept political dirt simply to try to cheat in the next election. I was certainly shocked by the comments from the President's Deputy White House Counsel yesterday right here on the floor when he said, "I think the idea that any information that happens to come from overseas is necessarily campaign interference is a mistake." No, it's wrong. It's wrong in the United States of America. He also added information that is credible that potentially shows wrongdoing by someone that happens to be running for office if its credible information is relevant for the voters to know to be able to decide on who is the best candidate. This is not a banana republic. It's the Democratic Republic of the United States of America. It's wrong. Now, the single most important lesson that we learned from 2016 was that nobody should seek or welcome foreign interference in our elections. But now we have this president and his counsel essentially saying it's okay. It is not okay. It strikes at the very heart of what the framers of the Constitution were concerned about: abuse of power, betrayal by the President of his oath of office, corrupting the integrity of our democracy and our free and fair elections by entangling oneself with foreign powers. That's at the heart of what the framers of the Constitution were concerned about. Don't just trust me. We have several folks who have made this observation. The FBI director, the Trump FBI director, said that the FBI would want to know about any attempt at foreign election interference. And the chair of the Federal Elections Commission also issued a statement reiterating the view of U.S. law enforcement. She said in part, "Let me make something 100% clear to the American people and anyone running for office. It is illegal for any person to solicit, accept, or receive anything of value from a foreign national in connection with a U.S. election. This is not a novel concept. Election intervention from foreign governments has been considered unacceptable since the beginning of our nation. It is wrong, it is corrupt, it is lawless, it's an abuse of power, it's impeachable, and it should lead to the removal of President Donald John Trump."
Thank you, Mr. Manager.
Mr. Chief Justice,
The Senator from Missouri.
I send to the desk a question on my own behalf and on behalf of Senator Lee.
Thank you. The question from Senators Hawley and Lee is for counsel for the President. United States federal courts have held, most prominently in the Blagojevich case, that it is not unlawful for a public official to condition his official acts on official acts performed by another public officer. Is there any application to the allegations against President Trump?
Mr. Chief Justice, Senators, thank you for that question. I think an important threshold point to make here is that we're not even in the realm of exchanging official acts because there's been no proof of a quid pro quo here. We're not in the realm of a situation where there's one official act being traded for another. I think that we've gone through the evidence that makes it quite clear that both with respect to a meeting with the President, a bilateral meeting, and with respect to the temporary pause on the security assistance, the evidence just doesn't stack up to show that President Trump linked either of those. Both took place, the meeting and the release of the aid, without Ukrainians doing anything, announcing or beginning any investigations. There's nothing in the transcript linking them as a quid pro quo. The Ukrainians didn't even know that there had been a temporary pause on the aid. And I could go on with the list of points on that. I think if there were any application, hypothetically, it would come in the realm of the fact that in foreign policy, there are situations where there can be situations where one government wants some action from another and wants that action from another in a way that will condition other policies of one country. You can say, we would like you, and this happens, for example, with the Northern Triangle countries. We want you to do more to stop the flow of illegal immigration. We're going to be conditioning some of our policies towards you unless and until you start doing a better job stopping the flow of illegal immigration, because it's a real problem on our southern border. That happens all the time. And when there's something legitimate to look into, there could be a situation where the United States would say, you've got to do better on corruption, you've got to do better on these specific areas of corruption, or we're not going to be able to keep having the same relationship with you. One example like that, I believe we pointed out that aid was held up to Afghanistan. President Trump held up aid to Afghanistan specifically because of concerns about corruption. And in situations like that, there'd be nothing wrong whatsoever with conditioning one policy approach on a foreign country modifying their policy to be more in line, to attune more directly to U.S. interests. That's part of what foreign policy is all about. And that could arise in the situation of even investigations. And I think it's interesting to point out that in May of 2018, 3 Democratic senators sent a letter to the then prosecutor in Ukraine suggesting that we've heard some things that you might not be cooperating with the Mueller investigation. And there is sort of an implicit indication behind the letter that there's not going to be as much support for Ukraine. This is something that's important. You've got to be helping with that election. And there's nothing wrong with encouraging the prosecutor general to assist with something that's important to the United States. That's part of foreign policy. It happens all the time. So to the extent that that case, the Blagojevich case is relevant, I think it is in the general concept that were there some linkage between we want your country to pursue these policies, it's going to affect our policies towards you, that's entirely legitimate. That's not something that is a violation of any law or is improper. But again, I come back to the point that here, there is no proof of that linkage. There is no proof that there was any sort of, as we've come to call it, quid pro quo in this case. Thank you.
Thank you, counsel. The senator from Washington.
Mr. Chief Justice, I send a question to the desk.
Thank you. Senator Cantwell's question is for the House managers. In his opening remarks, Chairman Schiff said the Ukraine scheme was expansive and involved many people. Is there any evidence that acting White House Chief of Staff Mick Mulvaney, Secretary of State Pompeo, Attorney General Barr, or anyone on the outside were involved in this scheme to withhold military aid or obstruction of Congress?
Mr. Chief Justice and Senator, thank you so much for that question. If we remember Ambassador Sondland's testimony where he said everyone was in the loop, but we don't just have to take his word for it. During his hearing, Mr. Sondland discussed a July 19th email he sent to the President's top aides, including Secretary Mike Pompeo, Acting Chief of Staff Mick Mulvaney, Mr. Mulvaney's Senior Advisor Robert Blair, Secretary Rick Perry, and Brian McCormick, Secretary Perry's Chief of Staff. And we should at least start with, if we're serious about getting to the truth, issuing a subpoena for State Department emails. If you'll pay attention to the slide, in the email, Sondland stated, quote, "I talked to Zelensky just now. He is prepared to receive POTUS's call. We'll assure him that he intends to run a fully transparent investigation and will turn over every stone. He would greatly appreciate a call prior to Sunday so that he can put out some media about a friendly and productive call, no details." Mr. Mulvaney, in the email, acknowledges receipt and responds shortly, "I asked the NSC to set up the call for tomorrow," 6 days before President Trump, now infamous July 25th call, in which he told President Zelensky to conduct investigations into the Bidens and the 2016 election. Mr. Sondland sent an email to the president's top aides updating them on the status of the scheme. Again, quote, "Everyone was in the loop." On August 11th, Ambassador Sondland emailed Mr. Breckball to ask him to brief Secretary Pompeo on a statement he was negotiating with President Zelensky with the aim of, quote, "making the boss happy," the boss being the president, enough to authorize the investigation. Ambassador Sondland wrote to Mr. Breckball, and I quote, "Kurt and I negotiated a statement from Mr. Zelensky, to be delivered for our review in a day or two. The contents will hopefully make the boss happy enough to authorize an invitation." And he's talking about the invitation for a White House Oval Office meeting, which we know was much more critical and important than a sideline meeting at the UN. Yet, further evidence, and I quote, everyone was in the loop. Attorney General Barr reportedly responded at some point. There was a New York Times article that was done, and Attorney General Barr responded to that article by stating that he was aware of DOJ investigations into some countries and that he was concerned President Trump was giving world leaders the impression he had undue influence over what would ordinarily be independent investigations. He cited conversations the president had with leaders of Turkey and China, further demonstrating that there was concern about the president abusing the power of his office for personal political reasons. Again, it proves that everybody was in the loop, and we should want to subpoena and review those emails involving the State Department and others.
Thank you, Mrs. Manager.
Mr. Chief Justice,
Senator from South Dakota.
I sent a question to the desk on behalf of myself and Senators Moran, Daines, Ernst, Scott of Florida, and Crapo.
Thank you. Senator Thune and the other senators ask the counsel for the president. On March 6, 2019, Speaker Nancy Pelosi said, quote, "Impeachment is so divisive to the country that unless there's something so compelling and overwhelming and bipartisan, I don't think we should go down that path because it divides the country," end quote. Alexander Hamilton also warned in Federalist 65 against the, quote, "persecution of an intemperate or designing majority in the House of Representatives with respect to impeachment." In evaluating the case against the President, should the Senate take into account the partisan nature of the impeachment proceedings in the House?
Thank you, Mr. Chief Justice, members of the Senate. Absolutely, you should take that into account. That's dispositive. That should end it. Based on the statements that we heard the last time from our friends on the Democratic side, that's a reason why you shouldn't have an impeachment. Speaker Pelosi was right when she said that. Unfortunately, she didn't follow her own advice. We've never been in a situation where we have the impeachment of a president in an election year with the goal of removing the president from the ballot. As I've said before, that is the most massive election interference we've ever witnessed. It's domestic election interference. It's political election interference, and it's wrong. They don't talk about the horrible consequences to our country of doing that, but they would be terrible. They would tear us apart for generations, and the American people wouldn't accept it. Let me address in that context the importance of the vote for their inquiry, which also had bipartisan opposition. Now, they said, well, we were fine when Speaker Pelosi announced it. We didn't need a vote. The subpoenas were authorized. Then why did they have a vote? They had a vote because they understood they had a big problem that they needed to fix. But what's more important about the vote than the procedural issue? The important thing about the vote is that if you're going to start an impeachment investigation, particularly in an election year, there needs to be political accountability to the American people. You can't just go have a press conference. If you're going to say that the votes of the American people need to be disallowed, that all of the ballots need to be torn up, then at the very least, you need to be accountable to your home district for that decision. And now they are. And now they are. And if the American people decide, if they're allowed to vote, if the American people decide that they don't like what's happened here, that they don't like the constitutional violations that have happened, that they don't like the attack on a successful president for purely partisan political purposes, then they can do something about it, and they can throw them out. That's why a vote's important. But we should never even consider removing the name of a president from the ballot on a purely partisan basis in an election year. Important? I'll say it's important for that reason alone, and for the interest of uniting our country. It must be rejected. Thank you, Mr. Chief Justice.
Thank you, counsel.
Mr. Chief Justice.
Senator from Rhode Island.
Mr. Chief Justice, I send a question to the desk on behalf of Senator Duckworth, Senator Harris, and myself for the House managers and for the President's Council.
Thank you. The question from Senator Reid and the other senators is for both parties, beginning with the House managers. It has been reported that President Trump does not pay Rudy Giuliani, his personal attorney, for his services. Can you explain who has paid for Rudy Giuliani's legal fees, international travel, and other expenses in his capacity as President Trump's attorney and representative?
The short answer to the question is, I don't know who's paying Rudy Giuliani's fees. And if he is not being paid by the President to conduct this domestic political errand for which he has devoted so much time, if other clients are paying and subsidizing his work in that respect, it raises profound questions, questions that we can't answer at this point. But there are some answers that we do know. As he has acknowledged, he's not there doing foreign policy. So when counsel for the President says this is a policy dispute, you can't impeach a president over policy, what Rudy Giuliani was engaged in by his own admission has nothing to do with policy. It has nothing to do with policy. And let me mention one other thing about this scheme that Giuliani was orchestrating and the consequence of the argument that they would make that its quid pro quos are just fine. Let's say Rudy Giuliani does another errand for the President, this time an errand in China. And he says to the Chinese, we will give you a favorable deal with respect to Chinese farmers as opposed to American farmers. We will betray the American farmer in the trade deal, but here's what we want. The quid pro quo is, we want you to do an investigation of the Bidens. You know the one the President's been calling for. They would say that's okay. They would say that's a quid pro quo to help his reelection. He can betray the American farmer. That's okay. That's their argument. Where does that argument lead us? That's exactly the kind of domestic, corrupt political errand that Rudy Giuliani was doing gratis, without payment, at least not payment apparently from the President. So who's paying the freight for it? Well, I don't know who's directly paying the freight for it, but I can tell you the whole country is paying the freight for it. Because there are leaders around the world who are watching this and they're saying the American presidency is open for business. This president wants our help, and if we help him, he will be grateful. He will be grateful. Is that the kind of message we want to send to the rest of the world? That's the result of normalizing lawlessness of the kind that Rudy Giuliani was engaged in.
Thank you. I'm sorry, your time has expired. Counsel?
Came out of the manager's mouth. Open for business. I'll tell you who was open for business. You know who was open for business? When the Vice President of the United States, who was charged by the then President of the United States with developing policies to avoid and assist in removing corruption from Ukraine, and his son was on the board of a company that was under investigation for Ukraine, and you're concerned about what Rudy Giuliani, the president's lawyer, was doing when he was over trying to determine what was going on in Ukraine? And by the way, it's a little bit interesting to me, and my colleague, the Deputy White House Counsel, referred to this. It's a little bit ironic to me that you're going to be questioning conversations with foreign governments about investigations when three members of the Senate, Senator Menendez, Senator Leahy, and Senator Durbin, sent a letter that read something quickly like this. They wrote the letter to the Prosecutor General of Ukraine. They said they're advocates, talking about the congressman, they're strong advocates for robust and close relationship with Ukraine, and we believe that our cooperation should extend to such legal matters regardless of politics, and their concern was ongoing investigations and whether the Mueller team was getting appropriate responses from Ukraine regarding investigations of what? The President of the United States. And you're asking about whether foreign investigations are appropriate? I think it answers itself. Thank you, Mr. Chief Justice.
Thank you, counsel.
Mr. Chief Justice.
The senator from Oklahoma.
Mr. Chief Justice, I sent a question to the desk on behalf of myself, Senator Ernst, and Senator Crapo.
Thank you. The question from Senator Langford and the other senators is for the counsel for the President. House managers have described any delay in military aid and State Department funds to Ukraine in 2019 as a cause to believe there was a secret scheme or quid pro quo by the President. In 2019, 86% of the DoD funds were obligated to Ukraine in September, but in 2018, 67% of the funds were obligated in September, and in 2017, 73% of the funds were obligated in September. In the State Department, the funds were obligated September 30 in 2019, but they were obligated September 28 in 2018. Each year, the vast majority of the funds were obligated in the final month or days of the fiscal year. Was there, was there a national security risk to Ukraine or the United States from the funds going out at the end of September in the 2 previous years? Did it weaken our relationship with Ukraine because the vast majority of our aid was released in September each of the last 3 years?
Mr. Chief Justice, Senators, thank you for that question. And the short, straightforward answer is there was no jeopardy to the national security interest of the United States from the timing of the release of this money. As the question indicated, the vast bulk of funds in each of the prior 2 fiscal years were also obligated in September. So the fact that the funds were released here on September 11th and obligated by the end of the fiscal year was consistent with the timing in past years. There was, and it's also the case that at the end of every fiscal year there is some funding in this Ukrainian military assistance that doesn't actually make it out the door, that isn't obligated by the end of the fiscal year. We've heard the House managers point to the fact that Congress had to put something in the continuing resolution, a special provision to get $35 million of the aid extended so it could be used in the next fiscal year. My understanding is that every fiscal year there's some amount of money. It's not always that same amount, but there's some amount of money that has to be done for every year because it doesn't get out the door by the end of the year. Now, it's not just from the raw data that we can see that the funds went out roughly the same timing towards the end of the year, that therefore it doesn't suggest any great risk to Ukraine or risk to the national security of the United States. We know that from testimony as well. Ambassador Volker testified that the brief pause on the aid was not significant. And Undersecretary of State for Political Affairs David Hale explained that this is future assistance. And I mentioned this the other day. It's not like this money is being spent month by month to supply current needs in the Ukraine. It's 5-year money. Once it is obligated, it can go to U.S. firms who are providing material to the Ukrainians, and it doesn't get spent down finally and material shipped to Ukraine for a long time. So a delay of 48 or 55 days, depending on how you count it, and the money being released before the end of the fiscal year ends up having no real effect. It's not current money that's supplying immediate needs, despite what we've heard about the idea that on the front lines in the Donbass, Ukrainian soldiers are being put at risk. That's just not accurate. And we know that also from Oles Sevchuk, the Ukrainian Deputy Minister of Defense, who gave an interview to the New York Times and explained that the hold came and went so quickly that he didn't even notice any change. And remember, the Ukrainians didn't even know. President Zelensky and his advisors, Yermak and others, have made it abundantly clear. There was another interview just the other day with Daniluk, who, I might get his title wrong, I think he was the foreign minister at the time, but there was an interview just the other day that was published, and he explained again that they didn't know the aid had been held up until the Politico article on August 28th. And then he said there was a panic in Kiev because they were just trying to figure out what to do. Well, within 2 weeks, it had been released. And so we've also heard the idea that, well, it was just the fact of the delay that gave the Russians a signal and it gave the Ukrainians a signal, and that was what the damage to national security was. But the whole point is the leaders of the government in Ukraine didn't know. It wasn't made public. So they weren't being given a signal by that, and the Russians weren't being given a signal by that. So that theory for damage to the national security also doesn't work. There was a pause temporarily so that there could be some assessment to address concerns the president had raised. The money was released by the end of the fiscal year. There was no damage to the national security, either in terms of materiel not being available to the Ukrainians or in terms of any signals sent to any foreign power. The money got out the door roughly the same time as in prior years, a little bit more left over at the end that had to be fixed, but there's some left over at the end every year that has to be fixed with a rider on the next appropriations bill or continuing resolution. So no damage whatsoever to the national security of the United States. Thank you.
Thank you, counsel. Senator from Hawaii.
Aloha. I send a question to the desk for the House managers.
Thank you. The question from Senator Hirono for the House managers reads as follows. In contrast to arguments by the President's counsel, acting White House Chief of Staff Mick Mulvaney stated that President Trump held up aid to Ukraine to get his politically motivated investigations. He claimed, quote, "We do that all the time with foreign policy," end quote, "get over it," end quote. What was different about President Trump's withholding of aid to Ukraine from prior aid freezes? Are you aware of any other presidents who have withheld foreign aid as a bribe to extract personal benefits?
Thank you, Senator. I'll respond to the question, but let me begin with something in the category of you can't make this stuff up. Today, while we've been debating whether a president can be impeached for essentially bogus claims of privilege for attempting to use the courts to cover up misconduct, the Justice Department, in resisting House subpoenas, is in court today and was asked, well, if the Congress can't come to the court to enforce its subpoenas, because as we know, they're in here arguing Congress must go to court to enforce its subpoenas, but they're in the court saying, Congress, thou shalt not do that. So the judge says, if the Congress can't enforce its subpoenas in court, then what remedy is there? And the Justice Department lawyer's response is impeachment. Impeachment. You can't make this up. I mean, what more evidence do we need of the bad faith of this effort to cover up? I said the other day they're in this court making this argument, they're down the street making the other argument. I didn't think they'd make it on the same day. But that's exactly what's going on. Now, in response to the question about how does this aid different, this hold different from other holds, it's certainly appropriate to ask that question. The laws Congress passed authorizing this appropriation did not allow for the hold by this president, and as the GAO, the Government Accountability Office, found, it violated the law to hold the aid the way it did. Once the Department of Defense, in consultation with the Department of State, certified that Ukraine had met the anti-corruption benchmarks required under the law, there was nothing that would allow for a hold. The money had to flow. And that was intentional. Military assistance to Ukraine is critical to our national security. It has overwhelming bipartisan support. And recall that in the spring of 2019, the Defense Department certified Ukraine had met all of the anti-corruption benchmarks. The Department of State sent the Senate a letter saying that the benchmarks had been met. It issued a press release saying that the aid was moving forward. It began to spend the funds to help Ukraine. But then the president stepped in. Without legal authority, he secretly placed a hold on the aid. Now, the President's counsel in their presentation gives specific examples of past holds as if we cannot distinguish one for a corrupt reason and one that is for a policy reason. In many of their examples, the law explicitly provided the executive branch the authority to pause, reevaluate, or cancel foreign aid programs as the situation in a recipient country evolved. For example, with regard to foreign assistance to El Salvador, Honduras, or Guatemala, the law explicitly allows the Secretary of State to, quote, suspend in whole or in part that assistance if at any time the Secretary deems that, quote, sufficient progress has not been made by a central government on a host of priorities from respecting human rights to upholding the law. Those are the priorities that you, the Senate, agreed to, and the President was required to implement them. Similarly, aid to Afghanistan is subject to periodic reevaluations by law, and the law explicitly directs the Secretary of State should, quote, suspend assistance for the government of Afghanistan should it be assessed that the Afghan government is, quote, failing to make measurable progress in meeting certain anti-corruption, human rights, and counterterrorism benchmarks. The overthrow of the democratically elected government in Egypt, we've had that brought up as another example. Members of this body, including Senators McCain, Leahy, and Graham, pressed the Obama administration to suspend military aid. It wasn't hidden from the Senate. It was urged on the administration by the Senate. Senators pressed for that aid to be withheld because the law was clear in instances of a military coup, aid must be suspended. Senators McCain and Graham wrote an op-ed in the Washington Post, not all coups are created equal, but a coup is still a coup. Morsi, that's the deposed leader of Egypt, quote, was elected by a majority of voters, and U.S. law requires the suspension of foreign assistance. I could go on with examples. No one has suggested you can't condition aid. But I would hope that we would all agree that you can't condition aid for a corrupt purpose, to try to get a foreign power to cheat in your election. Now, counsel says that if you decide the prosecution has proved that he engaged in this corrupt scheme, if you decide as impartial jurors that the Constitution requires his removal from office, that the public will not accept your judgment. I have more confidence in the
Thank you,
American
Mr.
people.
Manager.
Mr. Chief Justice,
The senator from Arkansas.
I send a question to the desk on behalf of myself, Senator Cotton, Ernst, Young, Hawley, Risch, Fisher, and Hoeven.
Thank you. Senator Bozeman and the other senators pose a question to both sides. In the House manager's opening statement, they argue that it is necessary to pursue impeachment because, quote, the president's misconduct cannot be decided at the ballot box, for we cannot be assured that the vote will be fairly won, end quote. How would acquitting the president prevent voters from making an informed decision in the 2020 presidential election? The President's counsel goes first.
Thank you, Mr. Chief Justice, members of the Senate. That's exactly who should decide who should be president, the voters. All power comes from the people in this country. That's why you're here, that's why people are elected in the House, and that's why the president is elected. It's exactly who should decide the question, particularly in a case like this, where it's purely partisan. Here's the other thing, when we're talking about impeachment as a political weapon. They didn't tell you what they told the court over the holidays when they were waiting to deliver the impeachment articles. They went and told the court they're actually still impeaching over there in the House. Did you know that? They're actually still impeaching. They're coming here and they're telling you, please do the work that we didn't do, where we had 2 days in the House Judiciary Committee. We had the rush delivery for Christmas, and then we waited and waited and waited. But now we want you to call witnesses that we never called, that we didn't subpoena. They want to turn you into an investigative body. In the meantime, they're saying, by the way, we're still doing it over there. We're still impeaching. And they want to slow down now. They don't want to speed up. They want to slow it down and take up the election year and continue this political charade. It's also wrong. It's also wrong. Let's leave it to the people of the United States. Let's trust them. They're asking you not to trust them. Maybe they don't trust them. Maybe they won't like the result. We should trust them. That's who should decide who the president of this country should be. It'll be a few months from now. And they should decide. Thank you.
Thank you, counsel.
Chief Justice, Senator, I appreciate the question. President Trump must be removed from office because of his ongoing abuse of power, threatens the integrity of the next election. As we saw from the video montage, the president has made no bones about the fact that he is willing to seek foreign intervention to help him cheat in the next election. Now, counsel for the president says the next election is the remedy. It's not the remedy when the president is trying to seek to cheat in that very election. This is why the founders did not put a requirement that a president can only be impeached in their first term. Indeed, at that time, of course, there weren't term limits on the presidency. If it were the intent of the framers to say that a president can't be impeached in an election year, they would have said so. Now, they didn't for a reason, because they were concerned about a president who might try to cheat in that very election. Now, counsel, as I was getting to a moment ago, made the argument, if you make the decision as impartial jurors that the president has violated the Constitution, he has abused his power, he should be convicted or removed from office, that the country will not accept it. I have more confidence in the American people than that. But I will assure you of this. If you make the decision that a fair trial can be conducted without hearing from witnesses, the American people will not accept that judgment. Because the American people understand what goes into a fair trial. And they understand that a fair trial requires both sides to have the opportunity to present their case. We would like to present our case. We'd like to call our witnesses. We'd like to rely on more than our argumentation. There are a few things about this trial that Americans agree on, but one thing they are squarely in agreement on. Well, two. They believe a trial should have witness testimony, and they want to hear from John Bolton. That is the overwhelming consensus of the American people, and it's consistent with common sense. Let's give the country a trial they can be proud of. Let's show that at least the process worked and that we followed the founders' intent that a trial have witnesses. I don't think anyone can quarrel with the fact when you look at the history of this body and every
Thank you, Mr.
single
Manager.
impeachment.
Mr. Chief Justice,
The senator from Virginia.
I send a question to the desk for the House managers.
Thank you. The question from Senator Kaine to the House managers. If the Senate acquits the President on Article 2, after he violated both the Impoundment Control Act and the Whistleblower Act to hide the Ukraine scheme from Congress, what is to stop President Trump from complete refusal to cooperate with Congress on any matter?
In short, the consequence is there is no constraint on this president or any other. This gets to a point you've heard counsel for the president repeat over and over. Can you be impeached for asserting privileges? And I would add, no matter how bogus or in bad faith those assertions may be. No matter whether they are in court today arguing the opposite of what they are arguing before you today. And the answer is yes, the president can be impeached for using the assertion of baseless claims to cover up his misconduct. The House did not impeach the president over a single assertion of privilege. We impeached him for a far more fundamental reason, because he issued an order categorically directing the executive branch to defy every single part of every single subpoena served by the House. A president who issues orders like this is a president who can place himself above the law and a system of checks and balances. He can do whatever he wants and get away with it by using his powers to orchestrate a massive cover-up. The president's lawyers haven't disputed that point. They can't. It's obvious that a president that ignores and can ignore all oversight is a threat to the American people. Instead, they've argued assertion of a grab bag of legal privileges warranting this categorical defiance. These arguments are unprecedented and wrong. The first thing to note is the president's arguments conveniently ignore the October 8th letter sent at the president's behest declaring that the president will not, quote, participate, unquote, in the impeachment investigation. I won't participate. This blanket defiance preceded all of the other letters and creative OLC opinions the president relied upon. It made clear that the rationale for blanket defiance was the president's belief that he can declare his own innocence and make it illegitimate to investigate him. This was not about privileges or legal arguments. Those came later as his lawyers rushed to justify that Congress has no power whatsoever to enforce subpoenas against anyone. Let's be clear. They may claim that their October 8th letter where they said they will not participate was somehow an offer to accommodate. But what the real condition was that the House simply drop the impeachment investigation or place the president in charge of its direction. That wasn't a real offer. That was a poison pill. Now, what about the remaining arguments? The first point is that none of them justify his order to defy all the subpoenas. He never asserted executive privilege over any documents. And his remaining arguments that absolute immunity or agency counsel not being allowed to attend depositions have nothing to do with documents. Nothing. So none of his legal arguments even applies to his direction that every single office and agency defy every single subpoena for documents. And what about the total obstruction on the witnesses? Here, too, he never invoked executive privilege. Absolute immunity obviously couldn't apply to many of the lower-level officials we subpoenaed. The only remaining legal ground for defiance was the argument it's unconstitutional for Congress to prevent agency counsel from going to depositions. The fallback of fallbacks. Except this rule was originally passed by a Republican Congress and has been used repeatedly by both Republican and Democratic-led majorities and committees. It can't possibly justify obstruction of witness subpoenas. It's nothing more than a phony cover for an obstruction that President Trump decided upon at the outset. His arguments are thus incorrect on their own terms and fail to explain this categorical order. One final irony, even before the argument in court today. At a recent oral argument in the D.C. Circuit, they made the same claim they made today. Let's pull up slide 56. In litigation, again, to enforce subpoenas, the judge said they can make it a grounds for impeachment for obstruction of Congress. And the president's own lawyers said impeachment is certainly one of the tools that Congress has. We agree. It is one of the tools that you have. For when a president would use a categorical obstruction of investigation in his own wrongdoing, it is a tool that should be applied here. There cannot be a better case for impeachment on obstructing a co-equal branch of Congress than the one before you, where the obstruction is so complete and so categorical.
Thank you, Mr. Manager. The senator from Florida.
I sent a question to the desk on behalf of myself and Senator Braun, and it's to the President's counsel.
Thank you. Question from Senator Scott and Braun for counsel for the President. If Speaker Pelosi, Chairman Schiff, Chairman Nadler, and House Democrats were so confident in the gravity of the President's conduct and the overwhelming evidence of an impeachable offense that prompted the inquiry, why were the House Republicans denied the procedural accommodations and substantive rights afforded to the minority party in the Clinton impeachment? Additionally, why were the President's counsel and agency attorneys denied access to cross-examine witnesses during committee testimony and present the testimony of witnesses in defense of the issues under review?
Thank you, Mr. Chief Justice, members of the Senate. I don't know why they would do that. I don't know. They violated every past precedent. They violated all forms of due process. Now, they say that's a process argument, and it is, but it's more than that. It's more than that. If you feel confident in your facts, then why do you design a process that completely shuts out the president? Why do you cook up the facts in a basement skiff instead of in the light of day? Why do you do that? Why don't you allow the minority to call witnesses as they've had to do, have had the right to do in all past impeachments? And then they come here and say, by the way, we were fully in charge, so completely in charge that we locked out the President's counsel, denied all rights, denied the minority any witnesses at all. But when we come here, they still don't get witnesses. They want you not only to do their job, but to make the same mistake, the same violation of due process that they did. They said, well, let's just pick the witnesses that we want. The other ones are irrelevant, not relevant. In listening to Mr. Schiff over these months, I've come to a determination about what he means by irrelevant. He means bad for them, okay? He means witnesses that the president wants to call. So I don't know why they did that. I'll say something else. I'll say something else. I have respect for you and I have respect for the House. And when I first got this job, one of the first things I did is I went to visit Mr. Schiff, Chairman Schiff. I went to visit Chairman Nadler. I went to visit Chairman Cummings at that time. And I said, we're here to work with you, to cooperate where we can, but in the institutional interest, obviously, we'll participate in oversight. But if we have constitutional points to make, we'll make them, or we'll make them directly. And the administration has participated in oversight. Many, many witnesses have testified in oversight hearings. Large number of documents have been produced in oversight hearings. And in fact, in the letter that I sent on October 8th, I made the same offer. I said, look, this is not really a valid impeachment proceeding for all of the reasons that we've stated. But if the committees wish to return to the regular order of oversight requests, we stand ready to engage in that process. But that never happened. So I respect Congress. The administration respects Congress. But we respect the Constitution. We respect the Constitution, too. And we have an obligation to the executive branch and to the future presidents to vindicate the Constitution and vindicate those rights. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Oregon.
Mr. Chief Justice, I send a question to the desk for the House floor managers.
Thank you. The question from Senator Wyden for the House managers. The Intelligence Committee community is prohibited from requesting that a foreign entity target an American citizen when the intelligence community is itself prohibited from doing so. In 2017, Director Mike Pompeo's confirmation hearing to be the director of the Central Intelligence Agency, he testified that, quote, "It is not lawful to outsource to do so. How is that not an abuse of power?"
It is absolutely an abuse of power. And what's more, if you believe that a president can essentially engage in any corrupt activity as long as he believes that it will assist his reelection campaign and that campaign is in the public interest, then what's to stop a president from tasking his intelligence agencies to do political investigations? What's to stop him from tasking the Justice Department if he can come up with some credible or incredible claim that his opponent deserves to be investigated? Their argument would lead you to the conclusion that he has every right to do that, to use the intelligence agencies or the Justice Department to investigate a rival. And when they become a rival, it's even more justified. But you're absolutely right. If Secretary Pompeo is correct and you can't use your own intelligence agencies, you sure shouldn't be able to use the Russian ones or the Ukrainian ones. And here, we have the president on that phone call pushing out this Russian propaganda, this Russian intelligence service propaganda, CrowdStrike, the server, as if there was just one server and it was whisked away to Ukraine. The Ukrainians hacked the server, not the Russians. A made-for-you-in-the-Kremlin conspiracy theory that undermines our own intelligence agencies but suits the political interests of the president, and his legal agent, Rudy Giuliani, is out there peddling this fiction. The president himself is out there promoting this fiction, standing side by side with Vladimir Putin. But you're absolutely right. It would be a monumental abuse of power, and it is a monumental abuse of power. And if you don't think abuse of power is impeachable, well, don't take my word for it. Don't take Professor Dershowitz's word for it, or Jonathan Turley's word for it. Let's look to our Attorney General, This is what he said. Under the framers' plan, the determination whether the president is making decisions based on improper motives, something that Professor Dershowitz says we're not allowed to consider, based on improper motives, or whether he is faithfully discharging his responsibilities, is left to the people through the election process and the Congress through the impeachment process. The fact that the president is answerable for any abuses of discretion and is ultimately subject to the judgment of Congress through the impeachment process means that the president is not the judge in his own cause. Their own attorney general doesn't agree with their theory of the case. But again, we don't have to rely on Bill Barr's opinion or Alan Dershowitz's opinion or my opinion or the consensus of constitutional scholars everywhere. We can rely on our common sense, because the conclusion that a president can abuse his power by corruptly entering into a quid pro quo to get a foreign intelligence service or a foreign government, a foreign leader to do their political dirty work and help them cheat in the election, our common sense tells us that cannot be compatible with the office of the presidency. And if we say it is, if we say it's beyond the reach of the impeachment power, or we engage in this sophistry and we say, because you put it under the rubric of abuse of power, even though that was the framers' core offense, and you didn't put it under some other rubric, well, we won't even consider it. If we're going to engage in that kind of legal sophistry, it leaves the country completely unprotected from a president who would abuse his power in this way. That cannot be what the framers had in mind. The Constitution is not a suicide pact. It does not require us to surrender our common sense. Our common sense, as well as our morality, tells us what the president did was wrong. When a president sacrifices the national security interests of the country, it's not only wrong, but it's dangerous. When a president says, as we saw just a moment again, over and over again, he will continue to do it if left in office, it is dangerous. The framers provided a remedy, and we urge you to use it.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from Indiana.
I ask to send a question to the desk on my behalf and Senator Barrasso for the President's Counsel.
Thank you. Thank you. The question from Senator Braun and Barrasso for counsel for the President. The House managers have said the country must be saved from this president, and he does not have the best interests of the American people and their families in mind. Do you wish to respond to that claim?
Mr. Chief Justice, members of the Senate, while the House managers are coming before you and accusing the President of doing things, in their words, solely for personal and political gain, and claiming that he is not doing things in the best interest of the American people are telling you just the opposite. The President's approval rating, while we are sitting here in the middle of these impeachment proceedings, have hit an all-time high. A recent poll shows that the American people are the happiest they've been with the direction of the country in 15 years. Whether it's the economy, security, military preparedness, safer streets, or safer neighborhoods, they are all way up. We, the American people, are happier. And yet, the House managers tell you that the President needs to be removed because he's an immediate threat to our country. Listen to the words that they just said. We the American people, cannot decide who should be our president because, as they tell us, and these are their words, quote, we cannot be assured that the vote will be fairly won. Do you really, really believe that? Do you really think so little of the American people? We don't. We trust the American people to decide who should be our president. Candidly, it's crazy to think otherwise. So what's really going on? What's really going on is that he's a threat to them, and he's an immediate legitimate threat to them, and he's an immediate legitimate threat to their candidates because the election is only 8 months away. Let's talk about some of the things the president has done. We've replaced NAFTA with the historic MCA. We've killed the terrorists al-Baghdadi and Soleimani. We secured $738 billion to rebuild the military. There are more than 7 million jobs created since the election. Illegal border crossings are down 78% since May, and 100 miles of the wall have been built. The unemployment rate is the lowest in 50 years. More Americans, nearly 160 million, are employed than ever before. The African American unemployment, the Hispanic American unemployment, the Asian American unemployment has the lowest rate ever recorded. Women's unemployment recently hit the lowest rate in more than 65 years. Every U.S. metropolitan area saw per capita growth in 2018. Real wages have gone up by 8% for the low-income workers. Real median household income is now the highest level ever recorded. 40 million fewer people live in households receiving government assistance. We signed the biggest package of tax cuts and reforms in history. Since then, over $1 trillion has poured back into the U.S. 650,000 single mothers have been lifted out of poverty. We secured the largest ever increase for child care funding, helping more than 800,000 low-income families access high-quality, affordable care. We passed, as Manager Jeffries will recall, bipartisan criminal justice reform. Prescription drugs have seen the lowest price decrease, the largest price decrease in over half a century. Drug overdose deaths fell nationwide in 2018 for the first time in nearly 30 years. A Gallup poll from just 3 days ago says that President Trump's upbeat view of the nation's economy, military strength, economic opportunity, and overall quality of life will likely resonate with Americans when he delivers the State of the Union address to Congress next week. If all that is solely, in their words, for his personal and political gain, and not in the best interest of the American people, then I say, God bless him. Keep doing it. Keep doing it. Keep doing it. Maybe if the House managers stop opposing him and harassing everyone associated with him with the constant letters and the constant investigations, maybe we can even get more done. Let's try something different now. Join us. Join us. One nation, one people. Enough is enough. Stop all of this. Thank you.
Mr. Chief Justice.
The senator from Colorado.
Thank you. I send a question to the desk for myself and Senator Schatz and Senator Menendez.
Thank you. The question from Senators Bennett, Menendez, and Schatz is to the House managers. If the Senate accepts the President's blanket assertion of privilege in the House impeachment inquiry, what are the consequences to the American people? How will the Senate ensure that the current President or a future President will remain transparent and accountable? How will this affect the separation of powers? And in this context, could you address the President's counsel's claim that the President's advisors are entitled to the same protections as a whistleblower?
Senate, privileges are limited. We have voted to impeach the President for, among other things, Article 2 of the impeachment is total defiance of House subpoenas. And the President announced it in advance, I will defy all the subpoenas. What does this mean? It means there's no information to Congress. It means a claim of monarchical dictatorial power. If Congress has no information, it cannot act. If the President can defy, now, he can dispute certain specific claims, you can claim privilege, etc., but to defy categorically all subpoenas, to announce in advance you're going to do that, and to do it, is to say that Congress has no power at all, only the executive has power. That's why Article 2 is impeaching him for abuse of Congress. That's why, for much lesser degree of offense, Richard Nixon was impeached for abuse of Congress, for the same defiance of any attempt by the Congress to investigate. But this is, and what are the consequences? The consequences, if this is to be, if he's to get away with it, is that any subpoena you vote in the future, any information you want in the future from any future president may be denied you with no excuses, announce in advance, I'll defy all the subpoenas. It eviscerates Congress and establishes the department, the executive department, as a total dictatorship. That's the consequences. Now, I want to also talk about, and the motives. The motives are clearly dictatorial. But I want to also take a point, since I have the floor, to answer a question, to comment on a question that Senator Collins and Senator Murkowski asked yesterday. And they asked about the question of mixed motives. What if, how do you define, how do you deal with a deed, with a president who may have a corrupt motive and a fine motive? And how do you deal with it? And Professor Dershowitz said, well, you have to look at the, you have to mix, you have to weigh the balances. Nonsense. Nonsense. We never, in American law, look at decent motives if you can prove a corrupt motive. If I am offered a bribe, and I accept the bribe for corrupt motive, I will not be heard in defense to say, oh, I would have voted for the bill anyway, it was a good bill. You don't inquire into other motives. Maybe you had good motives. But once the corrupt motive and the corrupt act was established, there is no comparison. All of this is just nonsense to point away from the fact that the President has been proven beyond a shadow of a doubt, and the defenders don't even bother really to defend. They just come out with distractions. He's been proven beyond a reasonable to have abused his power by violating the law, to withhold military aid from a foreign country, to extort that country into helping his re-election campaign by slandering his opponent. Corrupt? No question. Violation of the law? No question. Factually? No question. They don't even make a real attempt to deny it. Everything is a distraction, and the one chief distraction is once you prove a corrupt act, that's it. You never measure the degree of maybe had decent motives too. So Professor Dershowitz, in talking about that, in talking about the absolute power of the presidency, was just absent from American law or any kind of Western law.
Thank you, Mr. Manager.
Mr. Chief Justice.
The Senator from Georgia.
I send a question to the desk for the President's Counsel on behalf of myself, Senator Ernst, and Senator Barrasso.
Thank you. The question from Senator Perdue, Ernst, and Barrasso for Counsel for the President is as follows. Please summarize the House of Representatives' three-stage investigation and how the President was denied due process in each stage. Combined with Manager Schiff's repeated leaks during the House's investigation, do these due process violations make this impeachment the fruit of the poisonous tree?
Mr. Chief Justice, Senators, thank you for that question. And the short answer, as I think I've indicated a couple of the times that I've been up here, is yes, this entire proceeding here is now the fruit of the poisonous tree. It is the fruit of a proceeding that was fatally deficient in due process from the start to the beginning. And as a result of that, it produced a record that is totally unreliable, can't be relied on here for any conclusion other than acquitting the president. And let me detail the three phases. First, the first error was that the House began the proceeding in a totally unconstitutional, unlawful, and illegitimate manner. It started an impeachment inquiry without any vote of the House to authorize that inquiry. And I want to spend a second on this because the House managers have spent a lot of time today trying to go back and argue about why their proceeding was all right. But they're not actually engaging the real issues. In order for the House to exercise the power of impeachment, there has to be a delegation of that authority to a committee. That's just a fundamental principle that the Constitution gives power to the House itself, not to individual members of the House, not to the Speaker. Just as here in the Senate, you wouldn't think that the majority leader could say, if an impeachment arrived, the majority leader could say, guess what, we're not going to do a trial with the whole Senate. I, the majority leader, am going to just decide that I'm going to have one committee hear the evidence, provide a summary, and then you all can vote. The majority leader doesn't have the authority on his own to do that. The Speaker doesn't have the authority in the House to give the power of impeachment to any committee to start pursuing an inquiry. And this is the key. There is no rule giving any committee in the House the authority to use the power of impeachment. Rule 10 speaks of legislative authority, not the power of impeachment. And all the subpoenas that were issued came with letters saying on them, pursuant to the House's impeachment inquiry. They purported to be using a power that hadn't actually been delegated to the committee. That's the first flaw. Illegitimate, unlawful proceeding from the start. Then there are the due process flaws. 3 stages of hearings. 1, secret hearings in the basement bunker. President's locked out. No opportunity to cross-examine witnesses, to see the evidence, to present evidence. And then they go from that to the public hearings, what's really just a public show trial, because the president is still cut out, totally unprecedented in any presidential impeachment, that there would be that second phase of public hearings where the president is still cut out, can't present evidence. The minority members don't have equal subpoena authority. The third phase in front of the House Judiciary Committee, they purport to have offered rights, but I've explained that. It was illusory because they had already decided before the president was supposed to respond with what rights he would like to exercise. The Speaker had announced the result. There were going to be articles of impeachment. The Judiciary Committee had decided they weren't going to hear from any fact witnesses. They had no plans for hearings. It was all a foregone conclusion because they had to get it done by Christmas. And the third error, that Chairman Schiff was in charge of all the fact-finding, and he had an interest, because of the interactions of his office with the whistleblower that we still don't know about, to shut down questioning about the motive, the bias, the reasons that the whistleblower, how this all came about. All 3 of those errors infected this process from the very beginning. They resulted in a one-sided, slanted fact-finding that was rushed by a person controlling the fact-finding who had a motive to limit what facts would be allowed to get into the proceedings. And it produced a record that cannot possibly be relied on here. We've said many times, the Supreme Court has made clear that cross-examination is the greatest legal engine ever invented for the discovery of truth, and they didn't permit the president the opportunity to cross-examine anyone. And that's an indication that the goal was not a search for the truth. It was a partisan charade intended to justify a preordained result and to get it done by Christmas. And it's not a record that can be relied on here. Thank you.
Thank you, counsel.
Mr. Chief Justice,
The senator from Illinois.
I send a question to the desk for the House managers.
Thank you.